On the record, I just want to explain what we've got two cases that have been scheduled, one after the other. We're going to do them in order. We'll do one first, close the record out on that one, and then do the other one after that. So there's just to be clear. And the one we're going to start with is the one we noticed, which is I think was 8613. The one regarding the same one. That's right. Okay, good afternoon. We're here this afternoon in Public Service Board docket number 8613, which is the investigation pursuant to 30 VSA sections 30 and 209 into sound levels from the Georgia Mountain Community Wind LLC wind electric generation facility in Georgia, Vermont. Excuse me. I'd like to start by taking notices of appearance.
Barry Kasicki on behalf of the Department of Public Service.
John McLean.
Sash Lewis from Dunhill Saunders for Georgia Mountain Community Wind, and I'm here with Andy Rothvogel from the firm.
Okay, thank you. So you request oral argument?
That's right.
So if you'd like to reverse the
Thank you. Good afternoon, Board. Thank you for the opportunity to present oral argument. This investigation was open to determine whether operation of the Georgia Mountain Community Wind Project on the night of September 18th, 2015 exceeded the applicable noise limits for the project in the CPG. That question has been answered. We're fortunate that we have a full year of monitoring data from the project taken in 2013 that shows that the project never exceeded 39.5 dB measured directly at the McLean residence. And under conditions comparable to the night of September 18th, 2015, sound levels didn't exceed 34 to 36 dBA, using methodology that the Department of Public Service deemed reliable and that the hearing officer didn't disagree with. That is enough for the board to close this investigation. Nevertheless, we're here now because the hearing officer has recommended that the board require Georgia Mountain to offer attenuation testing to the McLeans, which is only required if the project is shown to be within 5 dB of the limit, or 40 dBA or over. To reach that conclusion, the hearing officer relied on 5 data points from February and November of 2013 that were reported in the first year compliance report as being over 40 dBA. But, as the hearing officer acknowledged in his report and recommendation, all 5 of those data points were contaminated with gusty wind, which under the technical standards that the board approved in the sound monitoring protocol for the project is invalid data. When that invalid data is removed from those 5 one-hour periods that the hearing officer relied on, the maximum sound level was just under 38 dBA, and the lowest was 29.5 dBA, which on the decibel scale is orders of magnitude less than the threshold we're talking about for outside-inside attenuation testing. Now, conducting attenuation testing at the residence is not a small matter. I think we can all understand the temptation to get to a place where we're just going to collect the data, but doing attenuation testing is an exercise that costs 5 figures by itself before you account for the burden Georgia Mountain bears to pay its expert, the department's expert, and pay for however many rounds of briefing are required to analyze and argue the outcome of the attenuation testing. But maybe even more important is the principle that is at stake in getting to attenuation testing here, which is that the technical standards that the board approved go out the window for us to get to a place where we find that the project was within 5 dBA of the limit. Now, the hearing officer distinguished the reasonable possibility standard that applies to the finding of being within 5 dBA on a fairly narrow ground. He noted that the technical standards that govern compliance testing under the monitoring protocol are set forth in Section 2 of the protocol. By contrast, the reasonable possibility standard for the complaint protocol is set forth in Section 3. And on that ground, the hearing officer concluded that the technical standards needn't apply to reasonable possibility because of this essentially schematic organizational fact of the monitoring protocol. What the hearing officer didn't account for is that the only technical standards in the sound monitoring protocol are in Section 2, which governs compliance monitoring. So if those technical standards don't apply, there are no technical standards to guide this determination whether there's a reasonable possibility that the project is within 5 dBA of the limit. Now, the technical standards of the sound monitoring protocol are binding on us as a matter of law. They are the standards set forth in the permitting document that the board reviewed and approved before the sound monitoring was conducted. Perhaps more importantly, the technical standards in the sound monitoring protocol they're derived from the science of acoustical engineering. They are the parameters that we need to abide by in order to achieve a reliable result. And I think that is why when you look at the Department of Public Service's proposal for the board's final sound rule, you see comparable or even identical technical standards guiding compliance determinations for wind projects going forward. Now, the Department of Public Service has proposed another way to get to this conclusion that attenuation testing is required. But like the hearing officer's report, the department's work sets aside entirely the technical standards that bind us in compliance determinations for this project under the CPG. They submitted a couple of memorandums from a company called Air Acoustics, which I won't go into it in great detail because it's on our briefing, but the Air Acoustics work ignores fundamental principles like subtracting background sound levels from project-only sound levels and setting aside rain-contaminated data, or even identifying data that exceeds 40 dBA. I think that itself shows the risk of casting aside the technical standards that the board approved for determining compliance with the sound levels for this project. I think that covers Georgia Mountain's case. I'm happy to answer any questions that the board may have.
Good, thank you. Mr. McLean? Do you have anything?
Well, I guess my feeling is, it's my wife and I whose sleep is disturbed with this. They are, according to the CPG, they're supposed to adhere to no more than 30 dBA over the course of an hour inside our bedroom. That's not the case. I mean, how can you have 40 or 45 outside the house? And we've seen from attenuation data from other projects that are probably on par with what ours would be. So, they're out of compliance. They're out of compliance because it's greater. We're subject to greater than 30 dBA in our bedroom on a regular basis.
So if the hearing officer recommended that they do attenuation studies, which would require them to bring equipment in and measure inside your house, are you agreeable to that?
My wife and I have talked about this. I'll be honest with you, we have no confidence in the developer's experts, RSG. We would have issues with them, but there are other people out there that we would consider.
If the board were to hire an expert, would you agree to let that expert, or if the department were to hire an expert, would you agree to allow that expert to
Probably,
do the
yes.
measures?
Yeah.
Thank you. Anything else you want to add?
Just, we live with this day in and day out. They have unattended monitoring. They're going by numbers. They're not there firsthand like we are. We know what we're seeing. We know what we're hearing. We know what we're experiencing. It's just to, it's just there in our mind. We are probably some of the people that complain the most. I think it's been noted a number of times, and the reason being is because we're some of the closest people. There are actually people that are closer than us that we hear from, but they don't report to you guys. So whatever we're experiencing, they're getting it worse than us. So something needs to be done. They need to They need to operate this project according to the conditions of the CPG, and we don't feel they are.
I think we understand your position, thanks. Mr. Kosicki?
The Georgia Mountain Community Wind noise monitoring plan serves a number of distinct purposes and has a number of distinct functions. Chiefly among those, one is to lay out technical standards that are to be used to determine sound levels for purposes of determining CPG compliance. Another function of the noise monitoring plan is to provide for a framework to resolve consumer complaints. Georgia Mountain Community Wind's argument throughout this proceeding sought to apply the technical standards that are used for CPG compliance determinations to figuring out how to resolve a consumer complaint. Specifically, with what sorts of standards need to be used to make a determination of whether or not there's a reasonable possibility that sound limits exceed 40 dBA outside in an exterior fashion. In this case, the department is briefed this extensively, so we'll be short about this. It doesn't make a lot of sense to have those technical standards from Section 2 apply to Section 3. First and foremost, to determine whether there's a reasonable possibility that there is sound limits within 5 decibels of the exterior limit is just there to determine whether or not an offer is made to conduct attenuation measurement. There's no actual determination of sound limits for purposes of CPG compliance. And as the hearing officer noted in the proposal for a decision, the problem that all parties face right now is no party after the initial first-year sound monitoring is conducted has the opportunity to conduct a on-off, turbine on-off protocol or otherwise account for background noise when it's trying to determine what the conditions were at the time of a complaint. And as the hearing officer noted in the P4D, that forces the department to come up with unique and different ways of trying to account for that. Because if we use the technical standards put in place by Section 2, the CPG compliance portion of the noise monitoring plan, there's simply no way for us to ever come to a conclusion that under any circumstances there would ever be any kind of sound limit within 5 decibels because RSG's own analysis has thrown out any sound levels that approach that 5 decibel sort of buffer zone by saying that the wind's too gusty or whatnot. In that framework, there's no way for a party to ever sort of say under any circumstances that there could possibly be sound levels within that 5 decibel range. As a result, the department attempted to use a different approach. We admit throughout this proceeding that it was a very close call, but we still stand by that approach, and we think that it's appropriate to allow for the department to use technical approaches that differ from those that are outlined in the noise monitoring plan for purposes of CPG compliance, because we realize there are 2 very different functions.
So things that fall within Section 3.
Correct. However, there is still the issue with respect to RSG's own findings during the first-year monitoring that the hearing officer noted in the proposal for decision that found that there was at least 5 instances where there were sound levels recorded that were above 40 decibels. Now, in the latest round of briefing, Georgia Mountain Community Wind argues that RSG said that RSG has gone back and taken a look at that data and has said that actually none of those times was it above 40. However, the fact of the matter remains that in RSG's own first-year report published in March 18th of 2014, in every single instance where there was noise levels that were shown to be above 40 decibels, RSG went through and explained in detail why those were project-only noise levels. Those estimates were project-only levels. And now, say 2.5 years later, we have a new analysis that indicates that it's something different. Now, I think that it calls into question the veracity of RSG's methodology across the board. However, there's nothing to suggest in the first year monitoring report that those sound estimates were incorrect. In closing, I mean, the only thing that I will say is that the hearing officer recognized that the department's approach did not allow him to make the determination conclusively that there were sound limits, the project only sound limits above 40 decibels at the exterior. And we think that is fair. It was admittedly a very close call with respect to that analysis. However, the hearing officer also noted correctly that the analysis that the department did conduct lends weight to showing that there was a reasonable possibility that, particularly during those 5 times during the first year monitoring regime, that there were recorded levels in excess of 40 decibels. That alone is sufficient to trigger Section 3 of the noise monitoring plan and to offer attenuation testing.
And the attenuation testing would give more information about what is actually going on between inside and outside.
Correct. I mean, to the extent that if the focus, and I think Georgia Mountain is correct when they say that the core question that was posed in this proceeding was whether or not the CPG sound limits were exceeded on the date of the McLean's complaint. At best, Georgia Mountain could argue that yes, the exterior limits might not have been exceeded at that time. However, they ignored that there is a clear 30 decibel inside limit that's also at play, and the only way to determine whether or not that inside sound level was exceeded was to conduct attenuation testing. And we feel that that threshold is met to make that offer for attenuation testing of the claim listing.
Thank you. Board, if I could respond briefly. The department called into question the veracity of RSG's methodology, but the department confused 2 totally separate notions. It is true that the first year compliance report noted that all 5 of the data points that the hearing officer relied on were project-only data points, but the sole question for the compliance report was whether project-only levels were below 45 decibels, the exterior limit. All 5 of those data points were below 45, even if you include the contaminated, invalid data. But the question here is, what is the valid data point? What does the valid data tell us? And excluding the invalid, contaminated data, the project-only sound levels are less than 40 dBA in every instance, contrary to the department's assertions. Now, I'd also just like to highlight that doing this quote-unquote modeling to determine what the project sound levels were under conditions similar to September 18th, 2015, was the department's proposal in the first place. And so Georgia Mountain conducted the analysis, even though we already knew that the maximum sound level was 39.5 based on direct monitoring. But we did it. We found that the project-only sound levels were 34 to 36 dBA. And nonetheless, the department is calling for that result to be cast aside, and frankly, that calls into question whether this is an outcome-oriented proceeding from the department's standpoint. Now, as for the idea that we need to do interior monitoring, or sorry, attenuation testing because it's the only way to determine the interior levels, the sound monitoring protocol is what tells us when we need to do attenuation testing, not our desire for additional information or to know interior levels. And the sound monitoring protocol says that we only do that when there's a reasonable possibility that we're within 5 dBA. That phrase, reasonable possibility, doesn't exist in a vacuum. It exists in the context of an extrapolation formula that allows you to take the monitoring data and calculate a rough level at an area where you don't have direct monitoring data, because the reality is there were only a few monitoring sites during the first year monitoring.
Does reasonable possibility show up in Section 2?
Not in Section 2, it's only in Section 3 in the complaint protocol. And it exists because there were only a handful of monitoring locations, and to get an estimate of levels anywhere else, you'd have to use this extrapolation formula, which is frankly fairly rough. It's a simple estimate. This is not that situation. We have direct monitoring data at the McLean residence. So it's also a little disingenuous to suggest that the department is at a disadvantage because it can't conduct turbine shutdowns. If the department wanted to determine levels at any other location, the best way to do it would be direct monitoring, which we've already done. I have nothing further.
Anything else that we need to hear?
Well, I'd like to add that, during that first year of operation, there were, and I think we can agree that probably the loudest time for the winter with the project is going to be when they're running at or near full capacity. They, out of 2,000 plus monitoring hours, there were a total of, and I can't remember exact numbers, but it's single digits that they actually ran, hours where they ran full capacity. That's less than 1/10 of 1%. They're basing their argument that, well, but they never exceeded, based on that limited data set. Also, one of the things that we've learned is you can...
Is your point about that meaning that if they shut them down during those periods, it wouldn't be that harmful to them? Is that what you're suggesting?
No, I'm just saying that the project gets green-lighted based on a year's worth of post-construction data. And if during that time, had they not ever run at full capacity, they would have still been green-lighted because they would have claimed that they were never in exceedance. I'm just saying with a limited number of data points and from the experience that we have living there now, the same wind conditions from one day to the next, whether there's a small amount of precipitation, whether it's just subtle differences in atmospheric conditions affect the noise levels. So it's I just, they keep coming back during that whole year. They were never in violation. But I guess my point, and maybe the time to argue it would have been back then, but I didn't know enough at that time. But I'm just saying now that they, we've learned a lot living next to them.
Your point is the fact that they didn't violate the sound levels during that first year doesn't mean that they couldn't do so in the future.
Yes, exactly.
Board
And they didn't have an exact, they were extrapolating. They didn't have an exact day during the exact conditions during the monitoring periods to compare to that particular night that we complained. So my point is that we could have, it's a swag, or they're trying to estimate.
Right. I understand your point. There's not enough. There may not be enough valid data to use the extrapolation method for however that was phrased. I think that's your point, right?
Yes.
If I may, Board, I agree with Mr. McLean that this is not the time to argue about the sufficiency of the monitoring data, which was reported long ago with no comment from anybody. I'm not prepared to speak to the number of hours that the project is operating at maximum capacity, but I will say that a wind turbine reaches its maximum sound output long before it reaches its maximum power output. And so it is actually beside the point whether the project was at maximum capacity across the board for X number of hours. The question is, for how many hours was it operating at maximum sound power? Now, Georgia Mountain conducted 67 shutdowns in the first year, which was many more than were planned. And the reason it did that was because RSG wanted to obtain as much reliable, valid data under the loudest out conditions possible that it could. Now, as for achieving the exact conditions of September the 18th, 2015, first of all, the Department of Public Service found that RSG's work in modeling those conditions was reliable. And second of all, no party, not the McLeans, not the department, and not the hearing officer, has suggested that Georgia Mountain is going to redo any monitoring and capture the precise conditions of that night. At best, what is suggested is that we're going to attempt to do attenuation testing and then look back to that 2013 data that we modeled in order to determine the interior levels. So again, that's beside the point.
Right. I think we've heard from everybody. Oh, yes, sure.
You mentioned in your initial comments that alluded to the principle that would result in technical standards for data. Could you elaborate on that a little?
Sure. As I mentioned, the sound monitoring protocol enumerates technical standards in one place only, and that's section 2. And those technical standards are not anything special. They're just the technical standards that you need to abide by to get reliable data. And the technical standards that the department is proposing the board adhere to in its final sound. And so if if it's determined that those standards apply only to section 2 and not to consumer complaints, then what standards do apply to consumer complaints? The department took one tack in the first memorandum that submitted from Air Acoustics, and after we identified some fatal flaws in it, the department took another tack in a second memorandum from Air Acoustics. The hearing officer adopted neither tack and resorted to a third approach, none of which emerges from the sound monitoring protocol. So if we don't abide by those standards, we're all making it up as we go along, and frankly, I don't think that's good policy. Besides which, as Attorney Kosicki pointed out, this is a CPG compliance investigation. The scope of the investigation is whether we exceeded the CPG limits of the McLean residence on the night of the complaint. Does that answer your question?
Yes,
Thank you.
Okay, I think we concluded this oral argument for this docket, so we're going to adjourn in this docket, and then we're going to open a new record in the other docket. So now we are having an oral argument in docket, Public Service Board docket number 8734, which is the investigation pursuant to 30 VSA sections 30 and 209 into operations during icing conditions by the Georgia Mountain Community Wind LLC Wind Electric Generation Facility in Georgia, Vermont. I'd like to start by taking notices of the committee.
Aaron Kosicki on behalf of the Department of Public Service.
Scott McLean, neighbor to the project.
Sash Lewis from Dunfield Saunders for Georgia Mountain Community Wind, and I'm here with my colleague Andy Rockville.
I think you also asked for oral argument in this one as well?
That's correct.
So Graham should go ahead.
Thank you, Board. This investigation concerned whether the Georgia Mountain Community Wind Project operation under icing conditions on March 11th and 14th violated the winter operating protocol and the certificate of public good. Now, there is only one fact in the record of this investigation, and it is the fact that the parties reached a stipulation on, and it's simply this, that one or more of GMCW's turbines operated with icing present for a period of time on March 11th and 14th, 2016.
And you agreed to that, correct?
Yes, that's correct, we did. The order that the board adopted states that no additional facts are material in determining Georgia Mountain's liability for operating under icing conditions. That reading of the winter operating protocol doesn't account for some key language in the protocol that differs from the setbacks order that was relied on in determining the intent of the winter operating protocol.
And am I correct, the setbacks order comes after the protocol was in place?
That's incorrect, board member.
Oh, I'm sorry.
The
I'm trying to
setback
say it
orders
the other
came
way.
first.
Right.
Subsequently, Georgia Mountain filed winter operating protocol, which the board approved. Now, Georgia Mountain's argument was that not only icing, but extreme weather conditions are required to shut down the project. The reason for that is because the winter operating protocol stems not from an independent CPG condition, but from an investigation into the proper setback for the project, which was focused solely on safety, the safety of the public from being struck by falling or thrown ice. And for that reason, the determination when the project should be shut down should be rooted in safety, and that's why extreme weather conditions come into it. The board's order reasons that the setbacks order directing Georgia Mountain to submit an operating protocol did not mention extreme weather conditions, and therefore its intent was not to require those in addition to icing. But the order doesn't account for the effect of the changed language in the winter operating protocol that the board approved. And there are two other key phrases in the winter operating protocol that differ from the setbacks order, on which we have no guidance under the board's current order. Those are the fact that the operating protocol requires Georgia Mountain to curtail operations rather than shut down the project under certain enumerated conditions. Curtail is different than shut down, but we don't have guidance under the present order as to what it means. Similarly, it states that under the enumerated conditions, Georgia Mountain is subject to shut down, which is different from shall shut down. But again, the difference is not accounted for in the current order. The reason why overlooking this language creates a manifest injustice and warrants reconsideration is that it yields a result that is out of keeping with the board's findings in the setback proceedings and inordinately burdensome to Georgia Mountain Community Wind. If the only material fact to a determination of Georgia Mountain's liability is that there was some unspecified amount or duration of icing at any time, it is arguable that that requires us to shut down if there's a snowflake or a morning frost or a wintry mist. We just don't know. The presence of icing, period, doesn't provide us the guidance that we need to operate the project in a reasonable manner. As the hearing officer pointed out, and the board adopted this finding, that in the setbacks proceeding, the board found that there were something like 14 to 16 days of icing conditions in an average Vermont winter that would require a shutdown. But if there's no inquiry required into the amount or extent of icing that leads to a shutdown, that number of days goes out the window again, because the number of days in a Vermont winter when there's frost or ice or sleet is far greater than 14 or 16, which appears to be what the board had in mind.
Do you equate frost and icing? Are you saying they're the same thing?
Well, I don't necessarily want to concede that right here, but frost is ice. I mean, frost is frozen water. Snow is frozen water, as is sleet. And so if there's no inquiry needed beyond the word icing in a stipulated fact, it's very difficult to know what the boundaries are of our operational parameters. That yields a manifest injustice because it requires us to shut down far more than has any connection to the public safety considerations that gave rise to the winter operating protocol in the first place, which is an enormous burden at no benefit. Thank you.
Mr. McLean, if you want to comment on this?
Yeah. I testified in front of this board regarding setbacks. I presented a tremendous amount of material that indicated that, you know, vast majority of municipalities' setbacks were based on a percentage of height, 1 1/4, 1 1/2 times your overall height of the turbine. That was ultimately not how it was decided, but it was like 10. You ended up 10% plus the blade length, with the stipulation that there was this winter operating protocol to shut down to prevent, to minimize the risk to anybody that may be in the area for ice throw. You know, it's, one of the things that we've mentioned a number of times during during this complaint is you don't look up on the mountain and say, oh, they're iced up. That's not how it works. Typically, under the conditions that the wind turbines will ice up, is the mountain's socked in. And you can just tell, you know the conditions, you know whether they're conducive to icing. The way we know it's, in addition to that, we hear them. We've lived next to them for almost 4 years. We hear them on a daily basis running. We can tell when they're iced. And that's how we knew they were iced, those two particular instances. You know, the first night my wife complained, they were shut down. The second day we complained, they didn't shut them down. We were subjected to sound levels in excess of 50, you know, in the high 50s, low 60s for 8 or 10 hours that particular day. So my point is, you know, you can't have, if they want to operate them iced. If you can operate them iced, you're going to exceed the sound limits. You know, that's what it is. They just had to repair one of the wind turbines up there, one of the blades. For the last 3.5 months, we were subjected to an additional noise that has never been there in the past. After 2 months of them doing nothing about it, we complained. They supposedly looked into it, oh, it was nothing. We had audio recordings that we submitted for the complaint process, ended up being a damaged blade, like we had claimed in the beginning, likely from running with ice on them because of the aerodynamics and the induced vibration and stuff. It's possible that that contributed to the blade getting damaged. You know, it's running with ice is just, I mean, it's it's contrary to the winter operating protocol. It was put in place specifically for that reason. Green Mountain Power has cameras to monitor ice on the blades now. Georgia Mountain has not done that. I mean, that's an option if they're concerned about, you know, the certain conditions. You know, again, it's, I think the hearing officer, Mr. Cotter, I think he summarized it very well in his write-up on it. I believe it's a clear violation of the winter operating protocol. You know, they're loud. They get loud when they're iced. You know, so whether or not the immediate, you know, whether or not, you know, during the proceedings for the CPG, it was argued that statistically the odds of somebody being up there in the event of ice throw or something is minimal, and you can't argue with that. It is the top of the mountain, but at the same time, if you're going to allow them to operate ice, you're going to have excessive noise levels, and there's nothing in place right now to monitor that. You know, if you allow them to operate them with ice, then we're going to be here time and time again, because there are going to be complaints about exceedances of the sound limits, noise limits. So, like I said, I think that I clearly believe they were in violation of the winter operating protocol.
Thank you. Mr. Kosicki?
There's no clear error or any other fatal defect contained in the board's ordering that would justify the alteration of that order. At this time, I think it's pretty clear that the sole issue that's presented here is whether or not extreme weather conditions are required to be present before a shutdown protocol is implemented when there's icing conditions pursuant to the 5 enumerated conditions that were set forth in the setbacks order. The department agrees with the claim that that's not the case. Extreme weather conditions are not required, and that the board's order is correct on that point. The setback order from 2011 was unequivocal that there should be turbine shutdown under those 5 enumerated conditions. There was no conditional language that surrounded that list. The order also acknowledged that the risk to public health from ice throw was minimal, but nonetheless, it required Georgia Mountain to shut down the turbines when any of those conditions were present. And furthermore, the board made a finding, or the board issued that order in reliance on a Georgia Mountain witness that confirmed that Georgia Mountain, it represented that Georgia Mountain would in fact shut down turbines whenever those conditions were present. This is fairly straightforward. The real question becomes is whether Georgia Mountain Community Wind, for purposes of this discussion, is able to graft on whatever language it feels fit as part of its winter monitoring protocol, can graft on language to the board's requirements that were set forth in the setbacks order. However, any language that they do graft onto it must be interpreted to be consistent with those requirements that are put forward in the setbacks order. Georgia Mountain provides no legal basis or no canon of statutory construction that would indicate that the addition of the extreme weather condition language that precedes the second paragraph in the winter operating protocol should somehow modify in any way the board's clear directive that it's set out in the setbacks order. As the department briefed, in this proceeding, that the enumerated circumstances that are set forth in the setbacks order could be read consistent with the setbacks because it contextualizes what constitutes extreme weather conditions. If the board were to accept Georgia Mountain's argument with respect to the requirement that extreme weather conditions must be present, it would lead to absurd results. Because in every instance where there's a question about whether or not a weather-related, ice-related shutdown must be conducted, there would have to be a subjective determination of what constitutes extreme weather conditions. I would argue that if you took an average person from, say, San Diego, California, and brought them to Vermont on an average February day, regardless of whether there's precipitation, they may argue that that's extreme weather conditions that have public health. And I don't mean to be flippant about it, but it points to the reality that the enumerated conditions that are put forward in the board's setback order give clear direction. The extreme weather condition language that precedes it does not give any direction to the board or to the parties in terms of when a shutdown protocol should be. Thanks.
So, Mr. Kosicki, the protocol that you alluded to, as you were hinting that it was chosen at will, but was it not approved by the board?
It was approved by the board, and I don't contest that it wasn't. However, I still believe that the board approved that language with the understanding that that language would be interpreted to be consistent with the directives that it laid out in the setback order. And the question really,
in the what order?
in the setback order. I think the crux of the board's analysis here is whether or not the department's and Mr. McLean's interpretation relative to Georgia Mountain's interpretation of the overall winter operational protocol is consistent with the requirements that were put out in the setbacks order.
Board, I'm frankly baffled by the department's position, which seems to be that Georgia Mountain snuck some language into the winter operating protocol and got it in under the wire. Georgia Mountain submitted it to the board for the board's approval, and the board approved it. I'm also struck by the board's position, which seems to be that
When the board approved it, didn't it approve it saying that we approved it on the basis that it was consistent with what we asked you to do?
absolutely, but the board also approved the specific language of the protocol, and the department's position seems to be that the board didn't really mean it. That, to me, is not how you do statutory construction.
Well, if your protocol that you filed was actually somewhat different from what the setbacks order required, it was incumbent upon you, don't you think, to call it to our attention? And I don't think you did that. So either what you filed was, you believe what you filed was consistent with the original order, and when we approved it, we said it was consistent with the original order. So to the extent that the protocol is inconsistent with the original order, then perhaps that is something that wasn't approved.
Chairman, I don't know the briefing history of the winter operating protocol in enough detail to answer specifically the question whether or not Georgia Mountain drew it to your attention, but I will say that I'm not aware of any statutory construction of a canon that allows you to render language surplusage in a permit document or a statutory document on the basis that the approving body was not put on sufficient notice of the contents of the document that it approved. That to me sounds a little bit more like a contract theory that doesn't apply in this context. The fact is that when the board approved the winter operating protocol, it approved a phrase that said that extreme weather conditions and presenting a risk of unsafety to the public was required for a shutdown.
And
Now-
would you agree, though, that you were supposed to put in a protocol order that's consistent with the setback order?
And I believe that it was consistent with the setbacks order. The setbacks order was not a granular document. It was not a highly fleshed out document, and it emerged from a large body of evidence having to do with the ice throw concerns that we've discussed. I'm also, on the self-policing issue that the department has raised a few times now, the department and I believe the board have a concern that if there's a degree of discretion about shutdowns, Georgia Mountain is going to be making this subjective determination and essentially self-policing. But the fact is that even under the current order, there has to be a subjective determination of some of those parameters. For example, whether meteorological conditions conducive to icing exist. That's not a standard that has been fleshed out. We have no numerical threshold that we're looking to. So the fact is that whether the department wins this debate or whether we win this debate, Georgia Mountain Community Wind is going to be in the position of making some subjective calls about how to operate the project, as any permit holder is in a regulated state. Now, as for the average Californian and their view on Vermont's meteorological conditions, all I can say is that we submitted an affidavit from a qualified meteorologist on the weather conditions at the top of Georgia Mountain on March 11th and 14th. And his conclusion was that the weather conditions are not extreme, and no one has called the reliability of that determination into question.
How do you define extreme weather?
Well, I'm not a meteorologist, but I think that extreme weather is, first and foremost, weather that presents a risk of unsafety to the public. And I imagine it could arguably be weather that falls outside some standard of deviation from wind speeds or temperatures or things like that.
Thank you.
Thank you.
Anyone see the need to respond to something that
You know,
they spoke last? Go ahead.
The issue that nobody wants to address here is the sound. You can't have, and I tried to emphasize it before, you can't have, any icing leads to excessive noise. So they're talking about, geez, it's going to be a subjective call and all this. Okay, so one day they're going to run an ice. We're going to have excessive noise. You know, so then what happens? It's if you're going to allow them, if you will, pardon the expression, this wiggle room with this icing, with this winter operating protocol, then there needs to be provisions in place to monitor the sound at the neighbor's residence, or they're going to be given the green light to operate out of compliance. Like I said, we didn't get any sleep that night until 1 or 2 in the morning when finally they quieted down. That particular night on the 14th, it was like 8 or 10 hours of 55 to 60 decibel sound readings outside our house. Senator Brian Campion happened to visit that particular night. He was there. He witnessed it. He stood right there and held the meter. He saw that there was very little or no ground level winds. We walked from our house, we walked to our neighbor's house. If you don't nail down this winter operating protocol, that's the sort of stuff that the neighbors get subjected to.
Thank you. Appreciate your all coming out today, and we'll take this under advisement.
Thank you. Thank you.